this shingling. Okay.
Very good.
Trevor Carroll, and Oscar, looking forward to today. Your Honor,
Good to see you. Keeping everything under control. That's like judges, you can't control it.
I've tried to learn that. My humility is growing.
I'm well, thank you. How are you? Good to see you. Good to be seen.
I just wanted to come up and say hi. Janice sends her regards.
Oh, you're right. I was behind the eight. No, I was behind the eight ball. The last time I went out was in.
And I'm here in Verstead. So it's good. Looking forward to it.
We had a retreat there, our first ever. And
Yeah, I know.
my own remarks, they were doing a big so I was holed up writing my remarks, and then we honored Henry Jackson, so I writing his remarks for him too. So I just remember how much So anyway, yeah, but we'll have to do it next time. Next time I'll have all the time in the world. How are things with you? Still working flat out. You don't like it? You didn't make it up, right? So where do you want to go?
Get this party started.
Him too.
All right, welcome everyone. Yay, we're here a second time. The second annual Justice Roger T. Hughes Memorial Lecture in Intellectual Property. Thank you all for joining us from near and far. Those of you who are here in the room, so many delightful, friendly faces, and some old and new, and some are joining actually via simulcast at the Federal Court of Canada here in Toronto to honor the legacy of one of Canada's trailblazers in our legal community, Justice Roger Hughes. Now, from the start, I would like to say thank you to Susan Peacock, Justice Hughes' wife, for all of her continued support in this worthwhile initiative, which is so close to our hearts. And also thanks to the Hughes family, and in particular Timothy Hughes and family for their ongoing support. And with us tonight is Susan. So Susan, a very warm welcome to you and thank you for everything. Now, I'm Professor Pina D'Agostino, a law professor at Osgoode Hall Law School and currently serving as the Associate Vice President Research at York University. And it's a distinct honor and privilege to continue to host this tribute to honor the legacy of Justice Hughes, who has been to me and to so many of us here in this room and across Canada, and really the world, a legal luminary, mentor, and friend. And I'd like to start by acknowledging the land on which this wonderful tribute is taking place, which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit First Nation. I have to say that even before we started organizing this beautiful occasion to be together, we received a flurry of emails just wondering, when is the date? When is this thing happening, and how could they help? And to me, this is a testament not only to how well last year's inaugural event went, with, of course, the phenomenal and most fitting inaugural lecture by the stellar Professor David Wever, and a very warm welcome to you, Professor Wever, who is here with Maxine Wever, and they actually flew in from Oxford to be here today with us. So thank you for being here. Thank you for being here for Roger, right? And on this note, all the buzz about this event is really a testament to Roger and his lasting mark on each of us. And I think that as an IP luminary, Roger would particularly like me saying that he left a mark on each of us. Now here tonight, and marked by Roger, is also the Honourable Marshall Rothstein. And he's shaking his head because he knows what he had to do to get here. He literally walked in about, a few minutes ago, straight from Vancouver. Thank you for being here. And I also know that Justice Manson wanted to be here, as he also was here last year, and he's been a keen supporter of this wonderful initiative and also has been marked by Roger. So many of the justices actually in this distinguished court, and I'm looking at them right now, and you'll hear from some of them very soon. Justice Furlaneto, very warm welcome to you. And the Honourable Paul Crampton, warm welcome to you. Thank you for being here and for being marked by Roger. Indeed, it is most fitting that we are reunited here at the federal court, as it was Roger's last professional home and where he left an indelible mark. Justice Hughes' legacy in the legal world spans over 5 decades. He began as an engineering graduate from Queen's University, 1963, then was a law graduate from the University of Toronto, 1966, and later built a prominent career as an intellectual property litigator. He argued numerous precedent-setting cases, including at the Supreme Court of Canada, and wrote influential works on federal court rules and practice and intellectual property law. Appointed to the federal court in 2005, Justice Hughes served with distinction until his retirement in 2016. Throughout his career and into retirement, he was a dedicated teacher and mentor, engaging with students and professionals on topics such as civil litigation and intellectual property, leaving an enduring legacy across the legal community. And I can attest to this firsthand. I have to say that I often find myself hearing Roger's voice and his wise counsel, and I'm sure, Susan, you've been hearing a lot of that. But for me, as a mentor and really giving me advice throughout my legal career and really supporting me and always being supportive, and that has left a lasting mark on me, and I'm forever grateful. And for this lasting mark on so many others, I am ever grateful to Susan Peacock, once again, Professor Wever, Maxine Wever, and Mario Bouchard, and matching funds from Osgoode Hall Law School for having established the Honourable Roger T. Hughes Bursary, which we announced last year. And I find this is a phenomenal initiative because due to their generous support, this endowment will help ensure that Justice Hughes' legacy and impact will be felt by law students long into the future. And there are many of students and aspiring students who have joined here tonight. And so it's a fitting honor that Justice Hughes, who devoted so much of his time to lift up and help students, would be having such an incredible initiative in his honor. So once again, thank you for that. And so I'm especially excited for tonight and grateful to so many of you for making tonight possible and being here. I know everyone has busy calendars, but this was the date to mark. Big thanks to the federal court and all the court staff, including Stan Shepard. Where is Stan? Are you here? Is he here? Of course, he's working. So he's phenomenal. And if we could give him a round of applause. Before, when we were setting up, he said he has so many stories on Justice Hughes, and he just loved working for him. And he said he's going to be doing this year after year. So that really warms my heart, because it just shows also the magnitude of his reach beyond every rung of society. On our side here of Osgood, we have Joseph Turcott, and Joe, I saw you're there, and Sandra Milani. Sandra, they've been indispensable in putting tonight together. Thank you. Oh yes, you have. So we say it's always like you're planning a wedding when we do these things, right? There's flowers. We're most grateful also to our founding sponsors, which collectively showcase a beautiful blend of academia, the legal profession, and the broader IP community. So here we're particularly thankful to our founding sponsors who have been dear friends to Justice Hughes and stepped up yet again this year. And I'd like to sing out thanks to Gowlings, and namely Kelly Gill, McCarthy Tetrell, Barry Suckman, SOCAN, Andrea Kokonis, and DLA Piper, Sangeeta Punyamurthy. And Sangeeta, I know I saw you before. There you are. Thank you. Thank you for your support, because we could not have done this without you. We also appreciate York's historic $318 million CFREF program, Connected Minds, Neural and Machine Systems for a Healthy, Just Society. And here, this is really about building a just future where the law plays a central role as we attempt to advance socially responsible technologies. And we know the world needs a lot more of that, including AI governance frameworks. I'm currently serving as the scientific director of this wonderful program, and I'm grateful to work alongside amazing talents, including the executive director, Caitlin Mullen, who is here with us. Thank you, Caitlin. And of course, we're grateful to the IP Innovation Clinic based at Osgood and York University, Canada's largest IP clinic, which serves inventors, researchers, and entrepreneurs and helps them recognize, protect, and commercialize their IP. Now, it's in its 15th year. Can you imagine? And we started this clinic under Justice Hughes's watch. And Justice Hughes was so proud of this little gem of a clinic that keeps growing and really shining on his sage advice from the very early days. We've undercut actually about $2 million, over $2 million, right, in otherwise billable fees, and that is over 5,500 hours of legal assistance, all resulting in many made in Canada successful companies. And for this, we have precious funding from Intellectual Property Ontario, that's IPON, and Communitech as part of the Government of Canada's Elevate IP program. So here, Joe, you're smiling. He's the Associate Director, of course, and the bedrock of the IP Innovation Clinic. And the entire clinic team has been phenomenal in putting tonight together. And I'd like to single out Francesca Piacente, Mina Zahin, as well as staff members and coordinators who are assisting, Xavier Thomas, Elia Rasky, as well as Marwa Asrar, Ginny Galpin, and George K. Thank you for stepping up. I should mention that this event is being recorded, if you haven't noticed already. And capturing your smiles, and I see many smiling faces here, is Buddha Photography, Maria. Thank you, Maria. Now, of course, if you should not want to be captured on camera, please let one of us know and we'll make sure we deal with it. Now, I have the honor to chair our time together, which will conclude outside of these doors with a cocktail reception, so where we started. And thanks to Santa Guida Foods, and with a special toast from the one and only Professor David Vaver. So that's to come. So why don't we get started with some words of welcome from Dean of Osgoode Hall Law School, Dean Trevor Farrell.
Good afternoon, everyone, and thank you so much, Professor D'Agostino. My name is Trevor Farrell, as Pina mentioned. I'm the Dean of Osgoode Hall Law School, and I couldn't be more delighted and proud to be here on the second annual of the Roger Justice Hughes lecture. And having been here last year at about a week earlier or what have you, but it's a remarkable event, and I'm so delighted that this is continuing. I will be brief, and my theme will be welcome too, really welcome and gratitude. And Pina's made my job easy. I would often want to recognize all the dignitaries from the court and from the community, and I won't do that for time and because Professor D'Agostino has done such a terrific job. But I do want to say how grateful we are for this event and to honor the legacy of Justice Roger Hughes. You know, I don't have to tell this room what a remarkable individual he was. And I think the things that come to mind, there's a couple pieces of lasting legacy that preparing for today was thinking about. You know, one is the bursary, and that's not a small thing. His name and the family will touch and impact students to come who face different kinds of barriers. And these are remarkable things that change people's lives. So we're so grateful for that, and that's one of the many lasting legacies of Justice Hughes. Teaching and mentorship. We're grateful for his legacy there too. And Pina has already mentioned the incredible 15-year innovation clinic that Pina started with others and the help, but really you, the brains behind the operation that made that happen. But I think you've rightly noticed the legacy that he brought to this and the lasting legacy that not only touches that community, that clinic, not only the clients, but also how we think about clinical legal education at Osgoode, which is a huge part of what we do. So we're grateful for that and the mentorship that he modeled. Another legacy that I would like to mention, really he can't take credit for, but his spouse. And Pina has also already mentioned Susan Peacock. Now, a graduate of this great law school in her own right, I can't help but think, Susan, I think you had better judgment of choosing law schools than Roger did. But maybe that's an unfair thing to say at this point. But we're grateful for his legacy and also your legacy, and for all of you that you've done. So thank you so much. Pina always celebrates everyone else. I could go on and on about my colleague, who now is basically running our university's research department as well, and amongst this world-class Connected Minds research project as its scientific director. But I do want to honor you, Pina, for bringing everyone together. I can't tell you how many people in the room I've already spoken to who basically come here and take the call because it's you on the other end of it. So we're so grateful for all the work you do. And then, of course, the sponsors and the friends who are here tonight celebrating. It's quite something. I think the last thing I will say, though, because I can't help it, I do have the floor for one more minute, is to honor the former Chief Justice Crampton, who's sitting right in front of me. And I had the great honor of serving Chief Justice Crampton on the Federal Court Rules Committee. That I made a very small contribution, but it was in one of those a million sort of moments that I see his legacy throughout the Canadian justice system, and it's remarkable what you've done. And so I just wanted to also honor you, Chief Justice, and thank you for being here tonight and what a remarkable legacy you have and have had in your own right. So with that, I will try and stay on time, get out of the way, and reiterate my thanks and gratitude to the group here, to the family, and to Justice Hughes. And I really look forward to our speaker tonight, Daniel Bereskin, which I know will be terrific, but I will let him be properly introduced by others. So with that, thank you, Pina.
All right. Thank you, Dean Farrell. And now I have the honor to introduce Justice Angela Furlanetto, who will say some welcoming remarks on behalf of the federal court. The podium is yours.
It's my great privilege to also welcome everyone here this afternoon on behalf of the Federal Court for the second annual lecture to honor the Honourable Roger T. Hughes. We are delighted to be hosting this event at the Federal Court and commend Professor D'Agostino for her work in continuing this annual event and organizing what is set to be another very interesting lecture this year. So I think we should give a round of applause to Professor D'Agostino. There is no doubt that Roger Hughes left an indelible mark on intellectual property law. First, with a long and distinguished career as a litigator and prolific writer, and then in his role as a judge. In addition to his cases, he authored numerous books on patent, trademark, and copyright law, as well as federal court practice, all of which continue to be a go-to resource for materials today. In practice, I was fortunate to have the opportunity to appear both against Roger in litigation and before him when he was a judge. As a litigator, he was a formidable opponent, and as a judge, a strong and commanding presence, quickly seeing through to the real issues and delivering sound and well-reasoned decisions that have served to develop and shape IP law. While on the court, he was a leader in every way, in the decisions he wrote, the initiatives he started, and the mentorship he offered. He was known for his deep intellect and ability to turn around well-reasoned decisions at an incredibly fast pace, which has served as the really high benchmark for those that have followed him. He also looked for opportunities to engage with the IP bar and advance practice initiatives through groups like the IP Users Committee. He started that, and that's just one example, while also supporting and mentoring young lawyers and students, both while at the court and afterwards in his work at Osgood, and you've heard about that already. When I was appointed as an associate judge, he was quick with his words of congratulations and encouragement for my transition to the court, giving me the advice to enjoy my time as he did. When I was then appointed as a judge, he again made a point of writing to me right away to provide some positive words and support for my appointment. Even though he was no longer at the court at the time, still then he went out of his way to make me feel welcome. I appreciated each of those notes immensely and still have them. It is with great respect that we are all here today to honor Roger Hughes. On behalf of my colleagues at the court, I am privileged to participate in paying tribute to him today through the continuation of this seminar.
Thank you so much, Justice Furlanetto, for sharing those candid remarks and really setting the tone for today. Thank you. So now it is time for our second annual Roger T. Hughes Memorial Lecture, and it is my honor to present to you Daniel Bereskin. Dan, as everyone most affectionately calls him, was appointed King's Counsel in 1982 and a member of the Order of Canada in 2020 for his leadership in the field of IP law in Canada and abroad. He is the author of the Canadian Law of Unfair Competition and of more than 50 papers and articles on various intellectual property law subjects. And he actually sent me one this morning. He was busy doing footnotes all weekend. He is a leader of IP law and founded one of the most highly ranked IP law firms in Canada. He is credited with shaping Canadian trademark law and advancing the competitive edge of Canadian companies worldwide. He is now principal at Smart Biggar, a prolific author. He has garnered international recognition for his influential writings and is the recipient of some of the most prestigious honors in the field. In 2017, Dan received a Lifetime Achievement Award by Managing Intellectual Property and was named Lawyer of the Year 2020 by Best Lawyers for Intellectual Property in Canada. He is a dear friend of the law school and of the wider legal community, a true gentleman, and always steadfast in contributing to IP debates in Canada and around the world with depth, rigor, and authenticity. And today's lecture is no exception. And I dare say there is no one more fitting to provide this lecture at this time, as I am told he has known Roger the longest of anyone in the room. Please join me in giving a very warm welcome to Dan Bereskin, who will speak on Brand Bandits, the threat to honest commerce from abusers of the trademark system. Dan, the podium's yours.
Thank you very much, Pina. After that very generous introduction, I was reminded of a way that my late friend Gordon Henderson responded when he said, "That was such a generous introduction, I can hardly wait to hear what I have to say." As Pina mentioned, I've known Roger a long time. In fact, since 1966. He had just graduated from U of T Law School and applied to us for an articling position. We were then 2 lawyers, virtually no clients. We had hardly any space, and so we couldn't hire Roger, to our regret. Fortunately for him, and frankly, fortunately for us too, he was able to article with Don Sim, who by then was a very renowned IP litigator. And it wasn't long before Roger himself became an outstanding IP litigator. Soon thereafter became a partner of Don Sim, and of course, as Pina has mentioned, an outstanding justice of the federal court. Following his retirement from the court, Roger and I served as judges of the IP Writing Challenge for quite a few years. And in all the years that we were doing this, I don't remember even once disagreeing with Roger's assessments. So if you entered the writing competition and didn't win, don't blame me. As the title of my address indicates, trademark systems throughout the world, including Canada, suffer from abusive registrations. There are 2 main types: trademark cluttering and squatting. Cluttering relates to the practice of procuring trademark registrations covering goods and services for which the applicant or the registrant had absolutely no intention of ever using in commerce. Overclaiming is a species of cluttering where somebody will register a trademark that is in use or intended use for some goods, but not for many others. Squatting is when somebody poaches an unused trademark in a particular country that hasn't yet been protected. In my remarks today, I will deal mainly with cluttering because it's the more commercially important type of abuse. At common law during the 19th century, and I want to assure you I was not there at that time, in order to obtain relief in a passing off case, it was usually necessary to call many witnesses. You had to prove goodwill, you had to prove confusion, you had to prove damage or a likelihood of it, and that required testimony. This was very time-consuming and expensive, and the results were not that easy to predict. So when the idea first arose of creating trademark registration statutes, the idea was to enable speedy and relatively cost-effective enforcement of trademark rights. That was the theory. Unfortunately, the rights created by registration have been abused by some trademark owners, including some of the largest. The abuse typically takes the form of procuring registrations covering a multitude of goods or services for which the applicant has absolutely no intention of ever using in a normal commercial manner. And the reality is, sad as it is to say, that legislatures throughout the world, with the exception perhaps of the United States, have failed to meet the challenge of cluttering. My feeling is that legislators just don't know the extent of the harm that cluttering causes, perhaps because it's very difficult to quantify, and the people who suffer don't have voices to speak up. Fortunately, the situation seems to be improving gradually, but progress is definitely being made. To give you an example of cluttering by a famous company, I referred to the trademark Coca-Cola. This has been registered in Europe under number 2107118 for a huge list of goods and services, including the following: leeches for medical purposes, preparations for destroying vermin, ironmongery, whatever that is, typewriters, and whips. The same Coca-Cola registration covers 15 classes. The description of goods and services amounts to 2,100 words, and the registration has been renewed and won't expire until 2031. Successful companies like Coca-Cola should realize that their conduct serves as a bad example to others and is harmful to the very trademark systems on which they rely. Cluttering affects the functioning of any trademark system by impeding the ability of trademark owners to accurately, quickly, and inexpensively assess the registrability of a trademark. To the extent that a trademark register contains registrations that don't properly reflect the legitimate rights of trademark owners, clearance of trademarks is uncertain, time-consuming, and expensive. And this is particularly problematic for small and medium-sized entities whose voices, frankly, are not sufficiently heard, I think, by legislators. And the cost of clearance of trademarks, especially if it's in multiple countries, is something that SMEs just can't afford. So the reality is that large companies don't, in general, complain about cluttering because they can afford the cost and the relative uncertainty, but SMEs cannot. So in 2019, the government, in their wisdom, decided to eliminate use in Canada as a requirement for registration. This had been in the books only since 1868, and they just got rid of it in a huge omnibus bill of at least 1,000 pages, buried amongst all kinds of other unrelated statutes. This change was made over the objection by trade associations, the INTA, law associations in Canada, trademark owners large and small, and more than 200 trademark lawyers from coast to coast. I wrote a letter to the Attorney General at the time proposing that a committee along the lines of the Fox Committee from 1948 to study this issue and to make recommendations. And of course, the recommendation, despite all the support that was garnered, fell on deaf ears. So here's an example of how this this legislation has worked out. I refer to a trademark application I've just encountered for the trademark Back to New. It's by a Burnaby, British Columbia company called Back to New International. They don't indicate any representative for service in the application, but I did a Google street search of their address, and I see that it's a private home. The description of goods consists of 51 pages of text, 59,000 plus words. And like the Coca-Cola registration, the goods include leashes for medical purposes. The description of goods also includes lice poison and other goods, which I'm advised by my wife and one of my sons is inappropriate to mention in polite company. Pity the poor examiner who has to study this application and consider its registrability. The same applicant has filed over three other applications, and the list of goods and services is just as phony. I'm a fan of the World Intellectual Property Organization. They have tremendous statistics that compare the administration of trademark systems and offices around the world. The latest statistics on this subject that I found date from 2023, but I don't think the situation has changed too much. Of the 200 plus countries monitored by the WIPO, in 2023, Canada ranked dead last in terms of the delay between the filing and issuance of the first office action, and dead last in the duration of trademark examination before final decision. In 2024, the wait times prior to the first office action was over 1,700 days, or about 4.5 years. So likely as a result, CIPO has recently hired about 100 more examiners to deal with the backlog. Who knows how long it's going to take to get these examiners up to speed. The government has stated the goal of reducing the backlog to 1 year. So far that goal hasn't been reached, but I'm glad to say that it looks like the situation is improving, albeit a bit slowly. The current delay between filing and advertisement is now about 18 months, which is a lot better than it used to be. One measure that has some relation to cluttering is class counts. The NICE classification of goods and services, as many of you probably know, comprises a total of 45 classes. Class count means the number of classes specified in a single trademark application. So WIPO has detailed records of class counts, comparing class counts by country, separated by applications filed by domestic applicants and applications filed by foreign or non-resident applications per year. In Canada, in 2023, Canada's class count for non-resident applications was a little over 89,000, behind only China, the EU, the UK, and the USA, all of whose GDPs and populations are substantially greater than Canada. So that's an indication of what the elimination of use, I think, has resulted in. Nothing that the government has done to date has been aimed specifically at notorious cluttering. However, the Act has been amended in some ways that hopefully will somewhat reduce improper use of the registration system. Section 38(2)(a)(1) introduced for the first time bad faith as a ground for invalidating a registration or opposing an application. Perhaps unnecessary for me to mention that there's no definition of what bad faith means, so it's going to be up to the judges to figure that out. And during the pendency of an application, examiners cannot cite bad faith as a ground for objection. For example, the examiner is unable to object to an obviously phony application like the back to new applications that I referred to based on bad faith. However, in the UK, since 2023, examiners are now allowed to raise bad faith objections at the examination stage, a practice that I think WIPO would be very wise to implement. CIPO has recently launched a pilot project to enable the registrar to issue Section 45 notices to owners of registered trademarks, requiring the owners of registered trademarks that have been on the register for more than 3 years to submit evidence of use in Canada, or where applicable, justification for non-use based on special circumstances. In January 2025, just a few months ago, or earlier this year, 100 such notices were issued, and as a result, 54% of the registrations were expunged due to failure to respond. That's an indication of how cluttered the Canadian Register is. Also in January 2025, 87 notices were issued by third parties under Section 45 of the Act requiring proof of use, and 68% of the registrations affected by the notices were expunged for failure to prove use. These are some of the very early indications of the extent of cluttering of the Canadian Register. New section 53.2.1.1 requires proof of use in Canada during the period of 3 years commencing at the registration date of the trademark as a precondition for obtaining relief for trademark infringement or depreciation of goodwill, unless there are special circumstances excusing the non-use. To serve as a real deterrent, I believe that except for extraordinary circumstances excusing non-use, a registered trademark that has not been used for all of the goods and services listed in the registration should not be permitted to apply for court relief. And that is so regardless of when the court action is brought. After 3 years, Section 45.1 provides that any person who pays the prescribed fee may request the registrar to issue notice requiring the registered owner to prove use of the trademark during the 3-year period immediately preceding the date of the notice. This is not an inexpensive procedure, and the cost and delay is too long for many persons who want to get on with their business. One of the regions of the world that is most notorious for cluttering is the European Union. And my theory, which is only a personal observation, is that when the people who drafted the trademark registration treaty decided to create a European trademark, they wanted to make it popular, especially among big companies. And so they made it so popular that it's very hard to stop somebody from overclaiming or cluttering the register with goods and services for which there's absolutely no intention of use. Article 59(1)(b) of the trademark regulation does say that a EU mark shall be declared invalid where the applicant was acting in bad faith when he filed the application for the trademark. Of course, bad faith is not defined. There's been a lot of litigation on what exactly that means, and nobody for sure knows exactly what it means even now. In 2011, the famous Max Planck Institute for Intellectual Property and Competition Law stated the following: there is no need to require intent to use as a precondition for filing in the EU, and this should only be envisaged if the current legal situation leads to massive grievances which cannot be resolved by other less radical means. So given this reasoning, it's no wonder that the EU register suffers greatly from trademark cluttering. I'm very pleased to say that I have had for many years a friend who is a very famous former UK jurist, the Right Honourable Professor Sir Robin Jacob. And in a British textbook, he expressed his consternation with the practice of cluttering in the EU as follows: it's apparent from the specifications of goods being allowed by OHIM that owners are being allowed to register for ranges of goods and services far wider than their use, actual or intended. This causes the office massive unnecessary work hours spent plowing through long specifications to find out whether buried in there are goods or services of which the mark is descriptive. Even more seriously, these overbroad registrations are likely to hamper trade. And of course, they put up costs for anyone seeking registration of a mark or contemplating using it. The problem needs resolution sooner than later. Rules are going to have to be developed to stop this nonsense. It's not good enough to say that there can be later part cancellation for wide specifications for non-use. Who would bother with the business, with the expense and time involved when they want to get on with their business? I've been, as I mentioned, a friend of Sir Robin for many years. I recently sent him a copy of my recent trademark reporter article dealing with trademark abuses, quoting the statement I just read to you. My email heading was Dan's latest heresy. So he wrote back right away, "Where's the heresy? A registration with an overwide specification should not only be found wholly invalid, but that the proprietor should pay a big fine for greed and have the mark wholly canceled. Just cutting out the bad part is no deterrent at all." So if you think any of the views I have expressed tonight are extreme, I seem to be in good company. As an example of the thinking in the EU, a case called the Orange Brand case, the cancellation division of the EU made the following, I think, rather curious observation. The fact that the EU TM proprietor may have filed for goods which are not the main part of its business or for which it has not commenced production does not immediately show bad faith. Indeed, most filings for trademarks are done in relation to a broader range of goods or services than is possibly needed. In the absence of bad faith, there's no prohibition against refiling an application for registration of a trademark, but the justification for refiling has to be genuine and not merely for avoiding the use requirement, which is something easier to say than to prove. I'd like to now refer to the situation in the UK. There was a very famous case involving a big UK company, Sky, which is in the broadcast and telecommunications business. And a US company called at the time Skykick wanted to register Skykick for email and storage products. And they were sued by Sky on the basis that this would infringe Sky's UK registrations and also their UK registrations. Skykick defended on the same ground that Sir Robin mentioned, that this is bad faith because Sky obviously had no intention of registering or using the trademark for the multitude of goods and services covered by the registration. So this was bad faith. The reality is, though, that Sky did use the trademark in the UK for at least some of the goods and services that are referred to in their voluminous registrations. So Skykick's position, in other words, was exactly identical to Sir Robin's view. The case in the UK was brought before Brexit, and so certain questions were then referred by the UK High Court to the Court of Justice of the European Union. The judgment of the European Union indicated that bad faith should not be presumed merely because the applicant had no economic activity corresponding to the goods or services covered by the application. Even if they didn't have any realistic expectation of using the trademark in the next 5 years. When the case came back, I think it was about 2 years ago, to the UK, actually a little bit before that because it went to the Court of Appeal first. And then the decision of the Court of Appeal was appealed to the UK Supreme Court. And famous Justice, Lord Justice Kitchen, wrote the judgment. The judgment disagreed with the Court of Appeal and sustained the validity of the Sky registrations only to the extent that there was in fact bona fide use or intention to use. And I'm not going to criticize anybody as learned as Lord Justice Kitchen, but the reality is that it's very hard to tell exactly what bad faith really means, even after this lengthy judgment. Because according to the court, you have to see what the registrant's business really is. What's its size and importance? Is there a rational explanation for a broad specification? what about the registrant's enforcement history? So, and this is also subject to the fact that the court can restrict the operation of a registration to distinct categories for which genuine use can be established. These comments are obviously very well intentioned and very well considered, but I don't see that they're going to discourage cluttering. See, my time is getting on. I have a few other countries I could mention, but I think I'm going to skip over China. China is notorious for cluttering, and as I mentioned at the outset, they have a huge volume of trademark registrations that probably cover goods or services that are never going to be taken into use. The situation in the United States, though, is profoundly different. The USA is not totally immune from cluttering, but unlike most other countries, it is a fundamental requirement of US law that enforcement of a registered trademark is conditioned on the active use of the trademark in commerce, and such use must inseparably relate to the goodwill of the business symbolized by the trademark. The really important thing, though, is that to file a trademark application in the United States, the statement of intended use or use has to be verified by a properly qualified individual. It's a statement that's made under oath, and that's unlike the situation in Canada or anywhere else. So when I have tried to figure out why the U.S. suffers so much less from cluttering than elsewhere, I think the fact that they require a verified statement of bona fide use in commerce or bona fide intention to use in commerce is a requisite of filing a valid application. And secondly, if a foreign resident obtains a U.S. registration based on a registration in the home country, that foreign resident cannot sue for infringement in the United States absent use in commerce in the United States. Secondly, between the 5th and 6th years from the registration date and every 10 years from thereafter, not only are registrants required to verify that the trademark continues to be used in commerce for all of the goods or services for which the registration is issued, but in addition, specimens have got to be provided evidencing such use for each class of goods covered by the registration. Believe it or not, it's not unusual for fraudulent specimens to be filed. It's very easy in the day of modern computer electronics to fake specimens, and a lot of people have done it. But it's a risky business, because if that could be proved, then the registration goes down the tubes. And similarly, when you want to renew a registration, you have to file verified proof of use supported by specimens. In 2020, the government passed the Trademark Modernization Act, which provides additional causes of action against owners of unused trademarks, including invalidity actions that are based on false declarations of use. It also contains important provisions intended to facilitate expungement of trademarks that are not in use in commerce or have never been in use in commerce at the date when the registrant swore that the trademark was so in use. So the expungement can be initiated not only by a petitioner, but also by the director of the USPTO and on the director's own initiative. And in addition to that, and this is not in usual circumstances, but where an application clearly looks like it contains phony descriptions of goods and services, the USPTO examiner can demand some evidence to support the allegation of intention to use in commerce. And that evidence is not difficult to provide if an applicant has a genuine interest in using the trademark. Examiners, of course, have access to the internet, and it's not difficult with the internet to determine whether a particular applicant has a realistic aim for using the trademark. So the example I cited, the company in Burnaby, BC, you look them up and you see that they have no business at all, and the home address is that of a residence. It's not hard to figure out that they're not in a position to make an honest statement of intention to use. I conclude with some observations on what I think we should do in Canada to improve the situation regarding cluttering. The first is to take a leaf out of the US book. And it's hard for me to say that, but I think in this one case, they're right. Trademark applications should contain statements indicating that the trademark has either been used in Canada or proposed to be used in Canada, and such statements have to be verified under oath before a properly qualified individual. And taking another leaf out of Sir Robin's book, any false statements of use in Canada or intent to use in Canada in respect of any of the goods or services should invalidate the registration in its entirety and should be a ground of opposition containing any such false statements, with the possible exception of extraordinary circumstances to justify such false statements. I think it would be very easy for the Canadian regulations to be amended to allow examiners to ask for proof of the applicant's bona fides in relation to a statement of goods or services that looks phony, like the example I've cited. And lastly, I think anyone should be able to challenge a trademark infringement action if it turns out the trademark is not in use for all of the goods and services covered by the registration at the time that the action is commenced. If a trademark owner wants to sue and there's a lengthy list of goods and services, some of which are not in use, it's easy for them to delete the goods and services before commencing action. And I think that's what should be done, rather than asserting a registration covering a wide variety of goods and services that are not in use. And as is the case in the United States, proof of use should be required by registrants between the 5th and 6th years, supported by valid specimens, and renewals should likewise be supported by verified statements of the use of the trademark in Canada for everything that is intended to be covered. So with that, I rest my case.
Thank you so much, Dan, for your outstanding lecture and also a call to action, right, to clean up the Canadian trademark system. And I feel that Roger is smiling, and you've really risen to the challenge set out by Professor Weber in the first inaugural lecture. So now it's my honor to present you with this. So maybe come up here at the front. So this is a plaque that will be permanently, we'll put it in the IP Innovation Clinic Suite at Osgoode Hall Law School. And your name is here, and Professor Weber's name is here, and he doesn't know this either. So this is also a surprise to Professor Weber, so please come up, Professor Weber. So the two of you should be here. And we get to hold it together because we thought of it this year to do this. So every year we innovate.
This was not with that consent.
Okay, looking
Then
here.
I'll come.
Arvin, got it?
Yep, got it.
Thank you.
Thank you. All right. There's more names there, so you'll see us again next year, right? So thank you so much. Thank you. I'll hang on to this here. All right. Okay. So now, as we, one thing I should mention also in terms of traditions, Professor Weber's lecture is published in the Intellectual Property Journal. And now the paper that I mentioned that was sent to me this morning, Dan Bereskin's lecture will also be published there. So that's a tradition, very fitting, because as many of you know, Justice Hughes was on the editorial board of the Intellectual Property Journal. So every year, we're going to populate it with stellar lectures. So stay tuned to that, and thank you so much again, Dan, for that. So as we turn to close the formal portion of the memorial lecture, I would like to invite up the Honourable Paul Crampton, who has just retired as Chief Justice of the Federal Court, to share a few concluding remarks. Just take this from
Thank you
here.
very much,
All right.
Pina. And thank you to Mr. Bereskin for that very thoughtful lecture. Makes me even more sad than I was last year when I missed your presentation, your inaugural one, Mr. Weber. I was not able to come to Toronto. Let me also add my words of greetings to Susan. So nice to see you again. Look forward to seeing you at the reception. So I was asked to make a few remarks about Roger's contribution to the court. Now, of course, one of the risks associated with going last is you risk being repetitive. I'll try to minimize the repetition. But Roger's contribution to the field of IP law in Canada has been so enormous that it's difficult to know where to start. So it's been mentioned that before his appointment to the court, he was a leading IP litigator, not just before the federal court and its predecessor. He actually litigated before the Exchequer Court of Canada. Marshall and Mr. Bereskin, you may be the only other two here. I don't know, Susan, were you around in those days? So that's really something. And then obviously the Federal Court of Appeal and the Supreme Court of Canada. He was a central character who was depicted in the 2014 play Seeds, which portrayed the 2004 Monsanto litigation before the Supreme Court. Roger was Monsanto's lawyer. It's been mentioned that he was a prolific author of many books, treaties, commentaries, scholarly articles on all IP topics, not just patents or trademarks, but also copyright and industrial design. I think maybe, and others can correct me if I'm wrong, if I understand correctly, his most famous, those that others may be aware of the most, might be Hughes and Woodley on patents, Hughes on copyright and industrial design, Hughes on trademarks. Certainly they were go-to resources at the court. In addition, Roger was at one time president of what is now the Intellectual Property Institute of Canada, and he was a frequent speaker at IP events and in law schools. So turning to the court, Justice Hughes was appointed on Friday the 13th of May 2005. Despite the ominous date, his appointment actually was very auspicious. It's difficult to think of anyone who made a bigger contribution to the court. He was one of our heavy lifters. He was the driving force behind the creation of the IP Users Group, which is a type of external liaison committee. We have them in a lot of our core areas of jurisdiction, and that was the first one to get up and running and provided a bit of a template for the other ones that came along afterwards. He was then its long-standing chair. and set the wheels in motion soon after creating that group to liaise with the bar and get buy-in from the bar to a number of innovative things that I'll mention in a minute. The minutes of that very first meeting that I've managed to get my hands on reflect that a big focus of his was on reining in discoveries, which were generally considered to be, and I quote, out of control, end quote, developing a process for getting early trial dates, and building in much more flexibility to the court's scheduling practices. So three of the major highlights from that group, which he deserves to take full credit for, were our 2007 Notice to the Profession on notices of compliance, which resulted in us putting notice of NOCs routinely into case management, and then moving them through the pre-hearing process much more efficiently than had hitherto been the case. Then our 2009 practice direction on the, I should stop saying our, the court's 2009 practice direction on the streamlining of complex litigation, and then the revision to the court's rules on expert evidence, which included the insertion of new rules on hot tubbing. And that was actually one of the first times I got to hear Roger speak. I think it was definitely in this building. It might have even been on this very floor where he unveiled those rules circa 2010, maybe 11, but it was before I was chief. Roger also made enormous other contributions to the Rules Committee as its chair, starting in 2010. In many ways, he was like an associate chief justice in relation to our IP work. Among other things, he triaged all of the files, all of the IP incoming patent trials, and then decided who would case manage those proceedings, and then those were the people who ultimately wound up being ordered to case manage them. He was generally considered to be our go-to person whenever anyone wanted to bounce around thorny issues or to receive some input on a draft decision. That mantle was then taken over by Justice Manson, and then after many years of yeoman's duty in that capacity, Justice Furlanetto is assuming that role within the court. So it's really nice that you were able to speak tonight and bring things full circle. Justice Hughes also gave seminars each year to our incoming clerks and the newer judges, and sometimes gave some internal seminars to more experienced judges. Before that, he was a frequent panelist at the Harold G. Fox moot. According to Westlaw, he issued approximately 450 decisions during his time at the court, almost a third of which involved the Patent Act. It was mentioned earlier, I think Justice Furlanetto mentioned that he was known for getting his decisions out quickly. I think maybe it was Mr. Dimmick who told me that one of the well-loved saws out there was, why does it take Roger so long to release his decisions for judgment? And the answer is because he had to wait for the trial to finish. He also had a great sense of humor. Two of the better lines of his that I've heard are, the Federal Court of Appeal is where good decisions go to die. And then, patent litigation is no different than any other type of litigation, as no stone can be left unturned, especially since you're being paid by the stone. So he continues to be remembered at the court with great fondness and affection. Thank you.
Thank you so much, Honourable Chief Justice Crampton, for bringing levity and fond memories of Justice Hughes, and a small token of our appreciation for you and your dedicated years of service.
Thank you very much. That's very nice.
And you get to keep this.
Okay, wonderful. I won't be using it.
So, yeah, thank you so much for your leadership and for being here tonight
My
and
pleasure.
just sharing time in this beautiful occasion.
Okay, wonderful.
Yeah.
Okay.
Excellent.
Can I use this like Maxwell Silver's hammer?
right, so now it's time to say thank you to each of you for being here to honor Justice Hughes, along with our incredible speakers from our outstanding keynote, Dan Bereskin, and our warm remarks, Dean Trevor Farrell, Justice Furlanetto, and the Honourable Paul Crampton. So now it's time for cocktails. So everyone should meet in the hallway as Professor David Vaver will kick off our mingling with a special toast. So see you in the next room. And for those of you joining online or by recording, because this is getting all recorded, thank you so much for joining in. And we look forward to seeing you next year at the 3rd Annual Justice Roger T. Hughes Memorial Lecture in Intellectual Property Law. So that's a wrap. All right, so see you in the hallway. Thank you.